Hi, this is Jim Cunningham, and welcome to Multi-Generational Estate Planning. This is a very popular topic with clients. I'm Jim Cunningham. I'm a lawyer. I'm talking. This is not legal advice. So don't look at this and go out and do a bunch of stuff. It's a really bad idea. If you're watching this on YouTube, we are recording it live. Go ahead and click the subscribe button on YouTube, and also click the little bell, and you'll be alerted when new content comes out. We release these about once a week. We have office locations throughout California, in Northern and Southern California. And we have a whole team of lawyers, and our entire focus in our firm is trust and estate matters and family wealth preservation and creation. And I'm the CEO and partner at CunninghamLegal. I have more than 25 years experience. We have helped clients in other states, so not just California. I'm a certified specialist in estate planning, trust and probate law, securities licensed, insurance licensed, and a pilot, single engine land. And for those of you who have not already bought the book, Savvy Estate Planning, our second edition is out. A lot of what we cover in today's materials, in today's webinar, a lot of this is contained in the book. So I would really recommend that you go to our website, order the book, and read it. And it's not like boring lawyer kind of talk, right? It's kind of how I'm talking to you. That's how the book's written. We tell lots of stories. We start with the Vikings. So kind of cool. What is multi-generational estate planning? What the heck is it? So I want you to really just kind of sit back, empty your mind, listen to what I'm going to be talking about. And for those of you who have questions, please put them in the Q&A. If you have questions and you're watching this on YouTube, you can put those in the comments. But whether your estate is large or small, many people are thinking about multi-generational estate planning. So this is planning for people, not just the next generation down, but the one after that. So this is fundamentally planning for grandchildren. You can kind of think of that. But having a multi-generational mindset can create tremendous benefit for the people that you love. Now, I live in California. Our primary area of practice is in the state of California. And as you know, California can be a very expensive place to live. And what I tell many of my clients is if you want to see your grandkids, sometimes you need to help out your kids, right? And so again, this is part of multi-generational estate planning. And it's not just about avoiding probate. That's so like 25 years ago when I first started practicing estate planning law, it was all about avoiding probate. And it's not even about minimizing taxes. It's about creating this family legacy that lasts for generations. So multi-generational planning, again, is the passing of wealth for more than one generation and building wealth with a plan of passing it on to future generations. And I believe this does require a shift in mindset. So a lot of people say, look, I made the money, it's mine. When I die, they can have it, but I'm not giving anyone anything while I'm alive. Well, if that's you, you can stop watching now. But if you say, wait a minute, my basic needs are met, I'm not going to outlive my money, I want to help other people, I want to help the people I love, then this really is for you, because this is really important stuff. Now, I will say most of our clients are not the ones who say, I'm just going to, I'll just let them deal with it. Most of our clients are really concerned about multi-generational wealth issues. So think about the benefits. If you have wealth beyond your basic needs, it can help provide the people you love with the financial means to maybe live near you, right? Or you might let a grandchild be a school teacher and live in Los Angeles, or a grandson to be a firefighter and live in San Francisco. And if you are a public service employee like that, many times it's almost impossible to live in those areas just because housing is way too expensive. So we'll also talk about protection of the wealth. I would say the biggest risks to wealth, number one, is just blowing it, like not being trained to handle assets. That's really common, but also divorce lawsuits and taxes. So I would say divorce and taxes, beyond people just spending it, it's divorce and taxes really take a big chunk out of inheritances. So something to understand, very few people successfully create multi-generational wealth strategy. 70% of wealthy families, now this is not all families, 70% of wealthy families lose their wealth by the second generation. What does that mean? Well, that means 70% of the people who die with a sizable estate, when their kids inherit it, it's gone. 90% if we're talking the next generation, if we're talking grandkids. So it's something, when you look at the threat of divorce and the threat of taxes and the threat of just spending the money, and we're going to talk about all this as we go through the materials here, It's very important to think about that. And it's very important to address it if you care. Again, if you don't care, then you don't care. But if you're watching this, obviously you care. I would say there's at least in, I would say American culture, if I can call it that, or Western culture or whatever it is, there is frequently a thread of a taboo of talking about money. People just don't talk about it. If you it's like Murphy's Law. If you talk about wealth, you'll lose it or something. I don't know. And it's also kind of private. So a lot of our clients live a normal life. They drive their little Tesla to Trader Joe's and they buy their own groceries and they make their own food and they have a $50 million net worth. And they don't want their kids growing up kind of spoiled and ruined. And they want their kids to live happy, productive lives. And that oftentimes involves delayed gratification. And we'll talk about that a little bit on training the next generation. And many times people are concerned that the second or third generation does not understand the value of money and how hard it took to accumulate it and keep it. And I would say that rarely do people have a comprehensive plan for preserving family wealth. So again, this is not just about avoiding probate. It's not just about avoiding taxes. How do you preserve this family wealth? And if you look at examples on the East Coast of the United States, because I talk to my colleagues, the lawyers on the East Coast, many times you will see multi-generational wealth going 5, 6, 7 generations. California was, we're not that old, right? We have 3 or 4 generations or whatever it is. But my point is that this does exist in other parts of the United States. Certainly in Europe, you'll have families who have had wealth for hundreds of years. And I would say that the preservation of wealth requires careful and considerate planning, meaning you really have to think about this. You really need to assemble an A team, if you will. And if you've been watching my videos, you know what I'm talking about. You need to assemble this team of advisors and pay attention to it. So we're going to talk about 5 big rock issues. So these are the big issues that we're going to cover today. And these are the ones that if you're concerned about preserving multi-generational wealth, you really need to pay attention to. Number one, you can kind of think of it as building a house, and that's why we call a foundational plan. Before you build the structure of the house, the very first thing you build is the foundation. If you build a house on dirt, on no foundation, that's not nearly as good as building a house on a solid foundation. And that is what we call the foundational estate plan. So the basic estate plan, typically a revocable living trust centered estate plan. And that we cover that in a lot of other webinars. We're not going to get into that today, but what it can do, we'll get into some attributes of a foundational plan that preserves wealth for 2 generations and potentially longer. And it's designed to protect from predators, creditors, and divorce. We will talk about, since we're talking about multi-generational planning, since we're talking about leaving assets to somebody 2 generations or more down from you, we have to talk about the generation skipping transfer tax. For many of our clients, it is an easily addressable issue. Let me put it that way. If you don't pay attention to it, it can be absolutely catastrophic. And we'll go through an example on how bad it can be. We'll also talk about training future generations. I think this is a really big issue because I've met with people when their parents pass away and they are shocked at how much wealth their parents had. And these people are very ill prepared to deal with it. And I've seen people squander it. So I think it's important, since I'm hopefully talking to the people who are going to be setting up the plan, or maybe the kids who are setting it up for the parents. It's very important to consider training the future generations on how to handle money. Just because you have $1 million doesn't mean you need to be, a lazy person and quit your job and spend all the money. You can have a lot of money in the bank and you can still be a school teacher or a lawyer or whatever, a doctor, whatever it is. Preserving Prop 13 tax base, I would say, is very important for the vast majority of our clients. I will say that the greater your net worth is, if you get up into, past 20, 30, 40, 50 million, people, it's less of a concern because other taxes, frankly, are a greater concern. And then, of course, we'll talk about death taxes. So creating what's involved in creating a proper foundational plan to ensure multi-generational protection. Well, again, in the 80s, it was about avoiding probate, and it's no longer enough. And what are the threats out there? We've talked about that. There's also other threats that could potentially threaten the person who's creating the plan, which is financial elder fraud. And that is rampant, folks. And it's something where elders are easy targets. And there are laws to protect elders, but frankly, it's too common for people to be taken advantage of. Long-term care costs I would say can wipe out people of moderate means. You know, if you've got a few $1,000,000, you can go through a few $1,000,000 caring for yourself or having others care for you. So, you know, you might be spending $20,000, $30,000, $40,000 a month each for in-home care. That's not, you know, we see that with clients. Divorce, creditors, and predators. We talked about that. And I would say that I talked to other lawyers, and there are lawyers that watch these, by the way. And I think too many lawyers are just focusing on avoiding probate, and that's it. And they're not really thinking sort of the next step, which is how do we preserve this wealth for multiple generations? So let's look at an example. I love examples because it you know, it's the story that that really kind of brings it all together. Hal and Wanda created a living trust centered estate plan 20 years ago, but now their wealth has increased. You know, if you think about what your wealth was 20 years ago, hopefully it's more. And for many people it is, but so is their knowledge. You know, we live in this wonderful era. I'm a lifelong learner. I got that from my grandfather, who started off as a farmer, right? And then went to college in 1928, and then went back to college in 1929. And then, you know, the Depression hit, and he went back to farming and later became a factory worker, he was a tool and die maker at General Motors Diesel in Detroit, helping power World War II and, you know, the industrial expansion after World War II. So I'm very proud of him. I'm very proud of the work that he did. And for those of you who have a background like that, you get what I'm talking about. He raised 3 sons with no college debt and put them all through college. And there is a thread, a cultural thread in our family of education, a love for education, a love for lifelong learning. And all of his descendants are college graduates. And this is something we're very proud of in our family. That's like a lot of other families. And so we live in this incredible era where you can Google stuff. You know, if you don't know how to do something and you're in the garage, you can take your cell phone out and you Google it and you see it on YouTube. I mean, it's amazing, right? So Hal and Wanda create a living trust 20 years ago. Their knowledge is increased. They're aware of all these issues, and they say, we want to do something about it. So Hal and Wanda create a restatement of trust that on the death of the survivor of Hal and Wanda creates what we call in our firm, we give it a name. It's called an inheritance protection trust. We discuss it in the book, what an inheritance protection trust is. I'm going to give you sort of the 10-cent tour. And these trusts are set up for Andy and Betty. 3 years later, Hal and Wanda die. 3 years later, Andy's third wife files for divorce, and Hal and Wanda's legacy for Andy is still in the inheritance protection trust. So this is a continuing trust that continues on after the death of Andy, or Hal and Wanda, and Andy's inheritance is protected, because if you just shove that money into Andy's pockets, there will be a question in the divorce proceeding. Is this community? Is this separate property? Yes, property. First of all property acquired during marriage is considered community property, except property acquired by inheritance or gift. And it's very important that you pay attention to that, because you can have property received as an inheritance, but later do stuff that means that it becomes community property. It's called a transmutation. We have a word for that in the law. It's transmuted to community property, and that is a 50-50 division at divorce. So Andy's inheritance remains protected because Hal and Wanda restated their living trust. So they keep the name of the living trust from 20 years ago. They restate their living trust, creating an inheritance protection trust for Andy. Well, let's say they create this inheritance protection trust for Andy, and now Andy dies, right? That wealth that has been protected in that inheritance protection trust, which has grown, goes to Andy's kids free of any death tax at Andy's death. And we're using the generation skipping transfer tax exemption. And for lawyers who are watching this, if you say, Jim, I did not hear anything about an inheritance protection trust in law school, it's a name that we internally give it to describe this type of trust with this type of functionality. So I'm a firm believer in giving things a name, okay, that it helps to keep the world straight. This is a general needs trust, okay, with generation skipping transfer tax provisions, and it's an exempt trust. So this would be allocated to the exempt portion of the general needs trust. So for lawyers out there, so you don't have to email me, I'm anticipating your question. So it's the key takeaway. It's no longer enough to do that plain old living trust that avoids probate. That's the old way of doing things. An inheritance protection trust keeps Andy's inheritance protected and is designed to last beyond Andy's lifetime. So this is that multi-generational component. I do want to highlight the more than a nudge. if you're going to do this type of a trust, I would highly recommend you consider a trust protector. We do have a few videos on our YouTube page, and we have a blog post on our website that discusses what a trust protector is. A trust protector, a living trust has a trustee. When you die, your successor trustee takes over. A trustee must follow the terms of the trust. A trust protector is an individual who has power over the trust, but is not the trustee. And the trust protector can do things like remove a trustee. And you might say, well, why would you want a trustee removed? Well, in this case, you got to remember, whatever your creditors can get to, whatever you can get to, your creditors can get to. So whatever Andy can get to in our example, his creditors can get to. So if Andy's the trustee of his trust, there is an argument, right? Hey, Andy, you're the trustee. If you can get to it, your creditors can get to it. So in order to kind of put a lid on the access to that trust, we have the trust protector remove Andy and typically replace him with a private professional fiduciary or trust company, not a trust bank, but a trust company. That way, Andy has no discretion to take the money out, and it's in the hands of an unrelated third party. It's very important. That's not an interested trustee, and that's defined in the Internal Revenue Code under 672C. So let's talk about the generation skipping transfer tax. We're going to move from foundational planning, and we do need to learn a little bit about the generation skipping transfer tax. Before 1976, this did not exist. So what the idea is the government wants to tax wealth at every generation. The government defines a generation as 37 and a half years. I don't know why they picked 37 and a half years. These are fiscal rules. There's no rhyme or reason. There's no reasoning in nature, nothing. It's just the way it is. So this is really important. If you want to give somebody who is 37 and a half years or more younger than you, if you give that person a gift or you leave an inheritance, that is subject to a generation skipping transfer tax. Now, it happens to be that you have to give more than $12,060,000 if you're a U.S. citizen or a green card holder. If you're a non-resident alien, it's a little bit different. It's only $60,000, right? But for most people that we speak with, it's really not an issue, right? I mean, unless you are giving, if you give a friend less, who's more than 37 and a half years younger than you, to the extent you give that person more than $12,060,000, you'll see what the tax is, and it's double taxed basically. So they want to tax it at each generation. But prior to 1976, it was kind of free reign, and wealthy families could make transfers. By the way, until very recently, that $12 million number was $1 million. So it used to be a very low number. So it used to be a much bigger deal. I would say don't avoid it. Don't not think about it, right? It's something you do need to think about, because that $12 million number will change in 2026. It's going to be cut in half basically, or it could be changed by statute. The generation skipping tax is a flat 40%. And again, if you're giving less than $12,060,000, it's not an issue. But let's say grandma leaves $22 million to grandson, and the first 12 million passes tax-free. The remaining 10 million is taxable, not only in grandma's estate at 40%, but what's left over, that 6 million that's left over, is taxed again 40%. So what you see is 6.4 million of that 10 million is paid to the federal government. They don't need it. They can print as much money as they want. Okay. This is designed to redistribute wealth. Quite frankly, it's in the Internal Revenue Code. The purpose of the death tax is to redistribute wealth. It's in there. Go look it up. And something to know, though, is if you're going to make a big gift to a grandkid, most people don't want to pay $6.4 million. So what can you do? This is, by the way, this is also known as a direct skip. Kind of makes logical sense. So what's a possible workaround? Well, grandma can leave $12,060,000 to grandson. And we'll talk about what kind of trust you can leave that in. But grandma leaves $12,060,000 to grandson and $10 million to the son. All right. And so that first $12,060,000 passes tax-free. The son or grandma's estate does pay for 40% of 10 million, but that saves 2.4 million in taxes. And if son doesn't have any assets, son could turn around and give that money to the kid, right? So you just need to pay attention to this. If you have a larger estate, or as this generation skipping transfer tax exemption amount, it's kind of a coupon. So you can think of it's a coupon to leave $12,060,000 to whomever you want, free of any tax, right now. You can think of it as a coupon. Okay. So the key takeaway, if you're wealthy, there are gotchas, and it pays to hire an expert. who knows the applicable rules. I will tell you what's happening in my industry. People really haven't been doing much of this planning since 2011 and really since 2009-ish. That's a long time ago. We're in 2022. That's 13 years ago. That's half a generation. A lot of the institutional knowledge, a lot of the lawyers who know this stuff, they're retired, passed away, whatever. They've gone to a different career. There are fewer lawyers to handle this type of work. And in 2026, that $12 million exemption gets cut in half to $6 million. So what's going to end up happening is there's going to be a significant increased demand, but fewer lawyers to get the work done. So we've definitely got a lot of work cut out for ourselves. So an indirect skip this is kind of getting in the weeds a little bit. So this is just something you need to pay attention to. It has intermediate steps. So you have a taxable termination and a taxable distribution. So a taxable termination would be grandma leaves a building in trust for son, and at son's death, the building goes to grandson, at which time the building is subject to generation skipping tax. So something to be mindful of is you just have to pay attention as a lawyer. How is this property being distributed to son? And so what we end up doing is there's a workaround with the generation skipping transfer tax. You end up with two buckets, exempt and non-exempt. I really don't want to get in the weeds, but something you need to know is if you're thinking multi-generationally, you really do need to, your advisors need to understand the generation skipping transfer tax. And then the taxable distribution is grandma leaves a building in trust for the benefit of a grandson, and there's no gift or death tax due, but payments to the grandson are subject to the generation skipping tax, and they're payable by the grandson. So that's in a case where there's no death tax due, but there is a generation skipping transfer tax due. Now, we don't see that much anymore because it's 12 million, but it used to be 3.5 million was the death tax exemption, and the million was the generation skipping transfer tax exemption. That's not in the law. That's going to be changed, but just be aware that those are issues out there. And so it does take a fair amount of training for a lawyer to understand these issues. Most beneficiaries avoid the generation skipping transfer tax because a lot of people aren't skipping a generation and leaving $12 million. So a dynasty trust. So here's kind of a solution. And here's kind of how we craft these in our firm, and frankly, most firms. A dynasty trust, if you Google dynasty trust, it's well defined. It's designed to avoid or minimize estate taxes and at each generational transfer. So as the property goes from one generation to the next, it's designed internally to maximize the tax benefits and minimize the overall tax. And it's designed to go from generation to generation without incurring additional, right? Because there might be some tax due, but without incurring additional gift and estate taxes, so long as those assets remain in the trust. And a lot of people say, well, can't I just give it to my kid? Folks, there's a reason lawyers create trusts. There's a reason rich people have lots of trusts, okay? They have lots of trusts because it helps the family, because it pays overall less taxes. So if you're the kind of person who says, I do not have any headspace for anything complicated, your family will pay more taxes. If you are open to accepting an appropriate level of complexity, we can do our firm, whatever firm you choose, can really help your family. And it was said, I think there was an Italian philosopher who said, if I had more time, I would have written a shorter letter. I will tell you that plans that leave our office are complex. We really try really hard to have them appropriately complex and not excessively complex. It's not make work stuff because frankly, we're too busy. People in my industry, they're just too busy right now. It's like make work, yeah, it doesn't even make sense. So consider a dynasty trust for multi-generational wealth transfers. That is something that if you hire our firm and you're talking multi-generational wealth preservation, you're going to hear that term dynasty trust a lot. And even if you go to another firm, they're going to use that term. That's kind of the common term that's used in our industry. Well, let's talk about training future generations. This is our third big rock issue. I think it's a gross understatement to say that not all family members are smart about money. Think about your own family. I think about my own family, right? And some people you just look at how they spend and you're like, you got to be kidding me. This is nuts, right? What are you doing? I think part of that's training. And something to understand is just because you have money doesn't mean you're financially literate. And I think a lot of lawyers, so if you're wealthy and you're going to hire a lawyer, many times the lawyer presumes a fairly sophisticated level of knowledge of what the lawyer's talking about. But what I find when I ask my clients is the vast majority of them, they're like, Jim, I don't understand any of this stuff. This is really complicated. So the whole point of like doing these videos is to help train people and help educate the client, because I vastly prefer working with an educated client than someone who says, yeah, just do whatever and I'll sign whatever. Okay. Lack of financial knowledge absolutely can lead to disaster. And I would say that people, my experience is we deal with a fair amount of wealthy clients, and sometimes people are embarrassed that they don't know. And sometimes in some wealthy families, they've kind of treated their children in a way where they've kind of not permitted them to learn about this stuff, right? So I would say that if you want to train future generations, you need to be mindful of this. And working with an A team is really paramount. You need to, whatever your A team is, typically it's a lawyer, financial advisor, and CPA is kind of the basic three-legged stools. But something else to be mindful of is inheriting family wealth or inheriting wealth can be viewed as a burden, okay? And it can be a source of stress. And so I think it's important to talk about this over a longer period of time. So here's our A team, right? This is the A team from the 80s, but really the A team I'm talking about is not that A team. It's the lawyer, the CPA, financial advisor. They formed this three-legged stool that you've probably seen in other videos that we've done. So training future generations, again, people are oftentimes uncomfortable talking about money with their children and grandchildren. I get that. It's easy to assume that easy to assume that wealth is a common topic with families. Well, guess what? For a lot of families, it's not. They don't really talk about it, right? It's something that's there. And I would say that people many times are ill-equipped when they receive an inheritance. They just aren't prepared for it. And it can lead to really loss. That's why, 70% of families preserve it on the second generation, or 70% lose it on the second, and 90% lose it on the third. I think a lot of times people just aren't prepared to inherit it. So open communication and transparency helps. I think one kind of exercise that you can do is, to keep the second or third generation from blowing it and prompting people to continue to work hard. Whatever it is that you do, there is a certain pride that comes with work, that comes sometimes with hard work. You get up, you go to work, and that's part of what you do, and that creates self-worth, and that's a good thing. You may not need the money, right? You may be independently wealthy and still teaching school or being a lawyer or being a judge or whatever it is. But that work gives you kind of a purpose, right? And it doesn't have to be paid work. It could be volunteer work. It could be, whatever it is. But, several $1 million sounds like a lot of money, but it goes fast. So remember, 30% of wealthy families maintain their wealth and only 10 maintain it into the third generation. And most millionaires today, by the way, did not inherit their wealth. They made it. So many of our clients have inherited some wealth, but for the vast majority of our clients, they were the ones that made it, right? That made the wealth. These are people that followed a plan, invested wisely, and worked hard. So I would say that some tips: communicate and collaborate on money matters. I would say one thing that I've seen some wealthy families do is when they get together for Thanksgiving. Now we're in the United States. Thanksgiving's that holiday that's the third Thursday in November. That's a really good time, because that's a time when people are thankful. You're reflecting on the year. You're thinking about family, and regardless of your origin or your background or your religion or whatever it is, this is like the one holiday, maybe apart from 4th of July, where all Americans come together. But this is one is really a time of reflection. Many families will sit around the Thanksgiving table and talk about, okay, we're going to make a charitable contribution. Let's talk about who we want to benefit, or let's talk about what causes we want to support. And, look what's happened this year. There's so many causes, whatever they are, whether it's, whether it's people, whether it's causes, whether it's environment or animals or whatever it is. But that mindset of being a steward of money, and it's not all about you and giving to others, I think really helps wealthy families kind of be sane and rational when it comes to money. So that's something I've seen, and I've been observing this for 25 years. So I've seen that's been a really helpful, a helpful thing to do. And I would also, talk about the advantages of planning and thinking about it, right? Delayed gratification tends to make people happier, right? There was that experiment, I think it was at UC Berkeley, where the marshmallow experiment and the kids who didn't eat the marshmallow had a more successful life, right? Broadly speaking. So incentives can also work. I think this tends to work for younger people. Match a child or grandchild savings with gifting, or you might say, hey, if you get a job and you're making 80,000 a year, I'll match that with 80,000 a year, or whatever it happens to be. But having a structure in place rather than just keeping it, and then when you pass away, they get it with no plan, with no culture attached to it, if you will. That tends to put you in that bucket of the 70% that lose it and the 90% that lose it. So, and in mistakes, people will make mistakes, right? I have 3 kids. If you have kids, you know what I'm talking about. And if you don't have kids, you probably know what I'm talking about. But people need to know that actions have consequences. That's the world we live in. That's just the basic law of nature. And they can be teachable moments. So if somebody steps in it, so to speak, you can use that as a, as a teaching moment, not to be punitive or rub people's noses in it, but really use that as a didactic sort of a teaching opportunity to really help them understand what it means to preserve and this wealth for multiple generations. If they don't get bailed out after blowing it, then they'll learn. So sometimes what we do is it's almost like the parable of the talents from the Bible, right? You give a little bit to somebody and see what they do with it, and they use that as a teaching moment. So that's kind of where I'm going with that. All right, preserving Prop 13 tax base. We have a couple of questions here. I'll take these questions. Alice asks, can one dynasty trust cover multiple generations, say 3 generations, or would each individual in those 3 generations need to set up a separate trust to begin with for the dynasty benefits to last? Alice, great question. There's a lot of flexibility when it comes to trusts, but here's what I would say on a high level. If you are operating as a single family unit, that family unit should have their own dynasty trust. So if you have 3 children and they're, 60, 61, and 62, let's say, you would do 3 trusts, right? One for each of those families. If you have if your children are 3, 4, and 5, you might do a single dynasty trust. And you can always break those up into separate trusts using a decanting, which is like you decant a bottle of wine into a decanter. You can change the terms of those trusts as time goes by, so you can kind of split the sheets. So but I would say it kind of depends on the situation. So great question. Anonymous asks, what are the differences between a dynasty trust versus an intentionally defective grantor trust, pro and con of each? Well, a dynasty trust sometimes is written as a grantor trust. So what that question asks is, what's the difference? Sometimes they're the same thing. So the way we often structure a client's estate plan, and this is really important, this is called a grantor trust. So under the tax code, if you can believe it, I can give away an asset and I can put $10 million into a trust. I do not get any of that money ever. That's a completed gift. I put $10 million in that trust. I'm never seeing that again. But if I retain certain powers, maybe the power to swap out property or to borrow without adequate security or to maybe name a charitable beneficiary, those are kind of the 3 big ones, or a trust protector has those, that causes that trust to be taxable on my individual tax return. So imagine I put in a $10 million worth of property, and then, there's some activity in that trust and it generates a $500,000 tax liability. I'm responsible for that tax liability. It is effectively a backdoor way of making an additional gift tax-free. That is a grantor trust. That type of trust, the Obama administration and the Biden administration have on their list to get rid of. So when you hear about getting rid of grantor trusts, when you hear about getting rid of those things, that's one of the type of trusts they're talking about. So saving Prop 13 tax base. Prop 13 is an important property right. So for those of you in California, when you buy a piece of property, that property could go up 6% a year, which property's done historically for the last 40 years. But by California law, the property can only be taxed at 1% of its market value plus a 2% increase every year. That's it. It doesn't matter if the property doubles or triples in value. Your property taxes can only creep up at 2% a year, which is frankly a lot less than inflation this year, right? So it's not uncommon for one neighbor to pay $2,000 a year in property tax and the next door neighbor to pay $12,000 a year in property tax on comparable properties. So a lot of people get upset about this. I think a lot of younger people get upset, but just wait, the longer you own the property, the more you benefit. If you bought a property 3 years ago, you're still protected by Prop 13. It's very important to understand. These really can't be ignored, but I will caution you, this should not be the tail wagging the dog. All right, because there are three big taxes in California that we really have to worry about: capital gains tax, death tax, and property tax. And many times people have to choose between two. You sometimes can't get all three. Sometimes you can. It's a question of how much juice do you want to wring out of the orange, quite frankly. So if you're the kind of person who says, I'll go that extra mile every day to wring out all the juice from the orange, then that's a strategy. I would say most people say, ugh, I don't have the headspace for that. I'll just, I'll take 2 of the 3. So this is a really big exclusion when it comes to residences. Okay, so this was passed effective in 2013. And let's say that grandma lives in a really nice house and she wants to leave it to her grandson. Grandma lives in the house and grandson lives in the house. Now, this is actually the situation. My middle daughter lives with my parents now. She's kind of starting out in life. She's got a job and she likes hanging out with grandma and grandpa. So she's living at their house right now. So that's an example of a grandparent and a grandchild living together. We kind of see this a lot in our firm. If grandma wants to leave grandma's home to grandson and grandson wants to continue that as his home, grandma can transfer 1% of her home to grandson. We typically do this in a dynasty trust, and grandma keeps 99%. On grandma's death, the 99% goes to grandson's dynasty trust. And so long as grandma and grandson both have that as their residence and only 2 people can be on title and someone has to die for the other person to not be reassessed, remember, someone's got to die in this, then there's no reassessment. The properties is not reassessed and the grandson takes the low Prop 13 taxes. Remember, Prop 58 was the parent to child reassessment exclusion that went away with Prop 19. So, this is one, I would say, not super common, but this actually does come up in our practice quite a bit. So preserving Prop 13 tax base and the LLC and the original owner. So grandma creates an LLC, 123 Main Street, and acquires an apartment building on Main Street with the LLC. So this is not where grandma buys the property in her own name and then puts it into the LLC. We'll talk about that on the next slide. Grandma and her LLC are protected by Prop 13. The LLC is what we call in Prop 13 law, the original owner, the original owner. And this is a really cool thing because so long as nobody ever gets more than 50% of this LLC interest and control doesn't change hands, then the property never gets reassessed, ever. Years and years and years, never reassessed. So I would say going forward, if you're investing in rental property and if these are legacy family properties, really think about creating an LLC and have the LLC acquire that property. The other workaround is if you recently purchased a property and you're like, oh man, I wish I would have known that. As long as the property, when it goes into the LLC, is reassessed, normally if the owner of the property is the owner of the LLC, property is not reassessed, right? If your proportional interest stays the same, but you can elect to have the property reassessed. And if that property is reassessed, that act of reassessment makes the LLC the original owner. Non-original owner, a little bit different. This is where grandma buys 123 Main Street and 5 years later puts it into 123 Main Street LLC. You see this a lot. You'll put the address followed by LLC. It's very common. Grandma, but not her LLC, is protected by Prop 13. Grandma's protected by Prop 13, at least under current law. When more than 50% of that LLC changes hands, the property is reassessed in its entirety. So if grandma gives 51% to grandson, the whole property is reassessed. So that's something that's very important to pay attention to. And I will caution you, if you're watching this, many lawyers don't understand these rules enough, okay? And I'm not criticizing lawyers. I'm just saying when I talk to other lawyers, I'm kind of like, wow, they really need to know this stuff. This is not easy stuff to learn. It's pretty dense, but it's very, very important if you're concerned about preserving Prop 13. So what can be done? What is done out there in the world? There is something called the step transaction doctrine. And what the step transaction doctrine says, if you do steps 1, 2, and 3, and you avoid taxes, but really you kind of put that middle step, that number 2 step in there just to avoid tax. They compress the 2 transactions. So you go from 1 to 3. That is called the step transaction doctrine. But in this case, grandma buys 123 Main Street. 5 years later, she puts 123 it puts the property into the LLC and then gifts grandson 50% of the LLC shares, because grandma wants to teach grandson how to deal with property, show him the ropes. How do you invest in property? You're going to be a manager. You're going to have some skin in the game. You're going to own this. 2 years later, grandson and grandma decide that wasn't such a good idea. You know, maybe this property isn't the best property. Maybe grandson, he's kind of lost interest. They decide to terminate the LLC and distribute the property to grandma and grandson. Given that set of facts, there should be no reassessment, because they're not doing this for tax avoidance. They were doing it because there was a narrative attached to it. Now, I'm not telling you do this and it's going to work. This is not legal advice. I'm giving you merely an example. So this is how other people have done it. Okay. Later, grandma and grandson change their mind and they go, well, maybe it is a good idea. Maybe we should keep this. You know, the situation's changed. Those crummy tenants got kicked out and now we're back on. So then they form a new LLC and they put that property into the new LLC. 2 years later, grandma gives her 50% of the LLC to grandson, no reassessment, and grandson has all the property. Now, grandma could also give 50% to somebody else, you know, whatever it is, but as long as no more than 50% passes, the property is not reassessed. And we do have a question. Anita says, if mom is the original owner for 30 years and now transfers the LLC, is it not protected? Anita, that would be a non-original owner LLC. So when more than 50% of the interest transfers or control transfers, the property is reassessed. Is there a time frame from the original owner? The next question is there a time frame from original owner to LLC before the tax advantages? Basically, the rule is if the property is reassessed when it goes into the LLC acquires original owner status. If someone has had a property for 30 years, they probably do not want to have it reassessed, is the bottom line. So there's, but you could consider this potential workaround. So let's talk about taxes. So taxes are very, very important. Most people, again, with the exception of non-resident aliens who happen to own tangible property in the United States, you know, if you're a resident of China, if you're a citizen of China and you never come to the US and you buy an apartment building in California, you have a $60 million exemption. So, or $60,000 exemption, not 60 million, $60,000 exemption, very low. So when you pass away, you're gonna have death taxes to pay. So most people get a $12 million death tax coupon for, and it's $12,060,000. For amounts over $12,060,000, it is a 40% estate tax. That is what the term that is used in the Internal Revenue Code. We use the term death tax not because we're trying to attach a political attribute to it, but it's because the term death tax also includes state death taxes. And so many of our clients have property in other states. And we'll see, we're going to have a few slides on what state death taxes look like. But if you say, man, it's time to get out of California, I'm moving to Washington, you're going to have an unpleasant surprise because Washington has a very high death tax, state death tax, even if you're not paying federal estate tax. So very important. And in Washington, it's 20% on amounts over 2.2 million. Unlimited marital deduction for married couples. So what that means is if you're married and you're a billionaire and it's community property and you inherit that, you know, 500 million from your spouse, no death tax. But when you pass away, 40% death tax. So grandma and grandpa have a combined net worth of 24 million. And until January 1, 2026, if your assets are over $6 million, you need to remember this date, January 1, 2026, because that $12 million death tax exemption is scheduled to get cut in half. And anything over 6 million is taxable at 40%. So there are no death taxes on this transaction. Grandma and grandpa have 24 million. But after that, it would be a $4.8 million tax bill. So we are meeting with lots of people who have a $24 million estate, and they know this because they've learned because of the internet and YouTube and all, you know, all this great stuff. They go, wow, 4.8 million. That's a lot of money. How do I solve this problem, right? How do you save 4.8 million in taxes? Well, grandma and grandpa form a Wyoming close LLC, and grandpa makes a gift of 12 million to a dynasty trust for son and the grandson, and that saves 4.8 million. We are burning one exemption, right? And that leaves grandma with 12 million. And as I'm reading this, I should have re-edited this to say grandma and grandpa give 24 million away and they stay on as manager of the LLC. That zeroes out the tax past 2026, or December 31, 2025. So just kind of forget how I wrote this slide. So I think I skipped over this one when I was getting ready for this webinar. But bear in mind, you're using a Wyoming Close LLC to make a gift, but still keep control. So imagine grandma and grandpa are driving the bus. They're in the front of the bus and the family's in the back of the bus. So grandma and grandpa are driving the bus and there's a pink slip. Well, they can sign the pink slip and hand it to the people in the back. So they don't own the bus, but they're still driving the bus. And that's kind of what we're doing here. So you're making that gift in a way where you're making the gift using a partnership with a dynasty trust so that you're using up these $12 million exemptions before they go away, because they're going to get cut down to $6 million. And given this example, there would be 12 million left and it would be you would be some taxes. So this is a bad slide. So we'll have to, just don't pay attention to this slide, just pay attention to me. So state death taxes, estate tax, we've got, you can see here, Washington, Oregon, Minnesota, Illinois, New York, and some Northeast. So those people are, those state income taxes are, state death taxes are out there. And when you pass away, if you are a resident of those states, you will have death taxes. And if you own real estate in those states, you will have death taxes. And there's a little bit of an end run around those is you can, if you have like a rental property in Oregon, many of our clients will create an LLC, typically in Oregon, and they'll put the real estate into the LLC. It then becomes an intangible. So if you're a California resident, you bypass Oregon's 16% death tax. So these are the death taxes. Hawaii has an estate tax of 20% on estates above 5.5 million. If you look to the right, you can see these numbers are a lot lower than 12 million, folks. So the state death taxes kick in when those on numbers much lower than the $12 million federal death tax. So if you're doing kind of some research and trying to learn on this, you need to pay attention where you live. You need to pay attention where your tangible assets are located. And I put in the bucket of tangible assets, real estate and deposits in state chartered banks. Who would have thought that the chartering of a bank determined what's going on? I think that's a risk. So you would want to go through a federally chartered bank or use a brokerage account. So we can see here, Massachusetts, a fairly low threshold of $1 million. And the biggie though is Washington, anything above 2.2 million, you're taxed at 20%. So big numbers there. So let's go through a punch list. What do you need to do? And then we'll wrap it up with some questions. Buy the book, Savvy Estate Planning. So this is about foundational planning primarily, and it prompts you to think about your legacy before meeting with the lawyer, helps you pick the right lawyer. Consider talking with your loved ones about wealth. Just think about it, right? I'm not saying run out and do it, but this is about mindfulness, right? And you're like, wow, I really should be thinking about this. And if you have assets greater than 6 million, you should consider planning ASAP. And what I mean by ASAP is now, because again, you have like half the people with institutional knowledge have retired, and there is going to be a traffic jam. I talk to lawyers in other firms because we do talk. These are big firms that also do the kind of planning that we do. Many of those firms stop taking people in the summer, right? This has happened recently. It's because people have an awareness and they're like, wow, this is real. I need to get into the attorney's office. And so they're just booked up. So something to be mindful of is if you're waiting till like October of 2025, I don't think you're going to be able to find anyone who knows what they're doing, is the bottom line. Assemble your A team, hire a reputable lawyer. This is another one. Hire a reputable lawyer to review your estate plan every 3 years. I would say looking at it every 3 years, think about 3 years ago. We're in 2022. 3 years ago was June of 2019. We live in a totally different world. So now I'm not saying every 3 years is going to be changed like that, but for many people, stuff changes in 3 years. You can buy the book from our website and then consider using the following documents: a revocable living trust. That's the foundational document. That's kind of the starting point, not the ending point. A will. If you have a living trust, you still need a will that leaves everything to the trust. That's how it's generally done. And durable powers of attorney for property management and personal affairs, as well as advanced healthcare directive. And get your A team. And that's not these guys, but it's a lawyer, CPA, financial advisor. And that is the end. And this is our YouTube page. I would really encourage you to kind of check out what is on our YouTube page. We have lots of content on there. And really, when I love it, I got to tell you something. For those of you who watch these, thank you so much, because I love meeting with people who watch these videos, because you are coming in so much more prepared, so much better informed, and frankly, more motivated to get this stuff done. It's like we're kind of matching, you and I are matching each other up, and it's like it works. So I really want to thank you for watching these and educating yourself. And how do you schedule a time? Go to our website and you can schedule a free call, or you can obviously, well, hey, make a payment. Well, that there's too. And you can give us a call or send in an email. We have a chat. We've got a whole bunch of ways for us to contact us. And subscribe to our YouTube page, click the bell, and you'll be alerted when we have new content. Please go to Google and give us a good review. For those of you who, I was just on the phone yesterday, she's like, you guys did such a great job. I referred a lot of people to you. So please do a Google review, because that really helps us. So we will open it up with questions. I will put on my spectacles. And does your company create idiots for clients? Yes, we create idiots. Not every hour, but lots per day. Let me put it that way. What parameters determine the 50% control or not in an LLC? Do these parameters differ between primary property and investment property? Alice, great question. I really don't like to put a personal use asset per se into an LLC. So for example, if you have a home and you put that in an LLC and you don't pay rent, I think that's a problem. You need to pay rent, right? Gavin Newsom lives in a home owned by an LLC. I have no idea who owns the shares of the LLC. That's another advantage of an LLC, is it's private, but you do have to pay rent. So if you have this LLC, whether it's taxable or not, it's a different question. But certainly investment properties, I really counsel clients to have the properties in an LLC. One common question that comes up is they say, Jim, that $800 minimum franchise tax is really annoying, because in California, if you're managing an LLC and that LLC is in Nevada, you got to register it in California. You're supposed to. And if you don't, I'm going to tell you, look, don't play that game. But that is what holds up a lot of people. So people say, well, I have this $1 million investment property, a $2 million investment property, and $200,000 condo, and a $500,000 single family home. I don't want to pay $3,200 in minimum franchise tax. My first response is get over it, because an LLC gives you lots of protection. It gives you lots of options to preserve Prop 13. But if clients don't like that answer, then I say, well, you could put more than one property into an LLC. Now, the problem is that reduces your creditor protection, but that is a workaround. But if you're getting upset about spending $800 on the minimum franchise tax, that we probably need to talk more about that. Anita says, thank you. It's always very informative. All right, thank you. If you have a property outside of your state of residence, do you put it in an LLC? Yes, great question, Anonymous. So many of our clients have rentals. A lot of people who have rentals in California find a couple of things happen. Number one, they're fully depreciated. Secondly, is the market value has gone way up. Third, sometimes the rents are lower, and sometimes the properties, because they're older, they just need rehab. So a lot of people will say, look, I'm going to sell this apartment building for $1 million. I'm going to go buy another building in another state for $2 million. So you get more basis, $1 million more basis. So you can depreciate that more, so you can pay less tax. And typically when you look at rents to values, although I think this has probably changed since COVID, when you look at what your rent is compared to what the price of the property, the value of the property is, you're going to get typically a higher rate of return outside of California. It's just a fact. It's just how it is. And so many people choose that as an income move and to pay less taxes. Now, if you were to do a 1031 exchange, let's say you sold a property in California and you did an exchange in Texas, you should probably have a Texas LLC for that, because the dirt is in Texas. So there's an element of logic there that the LLC should be in Texas. If you manage that LLC, you're going to have to register that Texas LLC in California. A workaround is to have a manager who's resident of Texas, who may appoint you as an agent of the manager. And again, if you're playing that $800 game, I'm not sure it's worth it. So I hope that answers your question. Agnes asks, did I hear correctly that you recommend not to put personal property, primary home into an LLC? Generally, Agnes, that's the case. Most of our clients use a qualified personal residence trust, and we have some information on that on our website, but that is correct, Alice. Did you register your LLC in your state and the state where the property is? Anonymous, yes. So California says if you're the manager of that LLC, and a manager of an LLC is kind of like the president of a corporation. They're doing all the work. If you're a California resident, you got to register in California. Is the LLC a good way to avoid Prop 19 property tax reassessment for the next generation? Alice, it can be, right? Especially if it's the original owner. But even if you're willing to engage in this sort of multi-year engagement where it's the gifting of halves on the LLC, that can really work for people. Anonymous asks, do you provide complimentary consultation for restatement of our existing living trust? We do that for our clients only. We do a 15-minute kind of a pre-qualification call, but most of those are paid. And that this is a function of COVID. Everything's going up. The people who do stuff for free, I wouldn't use them. Did you say that if the LLC is registered in Nevada and property is in California, you register the LLC in California? So if your LLC is registered in Nevada, okay, so I think I understand the question. I go to Nevada and I create an LLC. I'm a California resident, and there's a reason why you might do this. And then that Nevada LLC owns California property. Yes, you would have to register in Nevada and California because the property is located in California, or you're doing business in California. So the answer is yes. But this is why we don't, and I'm not giving you the full story. So the full story is if you create a California LLC, the next question is who owns the shares of those LLCs, right? We typically have a Wyoming holding company that holds those. So I'm not giving you the complete picture here, but some people do a Nevada LLC to own California real estate, but you do have to register those in both jurisdictions. Is it easy to create an LLC? Anonymous. It's easy for me. It's something that can be learned. And a lot of people say, well, I don't want to hire a lawyer. I don't want to pay all that money. It's really easy to create an LLC, but once you start putting California property into the LLC, you're going to have to deal with somebody called the assessor, the county assessor, because they will reassess the property unless you identify an exemption. And they're going to want to see something called the operating agreement. And so the operating agreement, I can tell you, there is no standard form, like statutory form of an operating agreement. If you don't have that correct, your property will get reassessed. Okay. Then you'll really need a lawyer, and it's going to be 10x the fee to dig you out of that hole. So it's something, if you're dealing with real estate, I would definitely hire someone who knows what they're doing. If you buy property as an original owner, then transfer to the LLC. If you buy as original owner, then transfer to the LLC, is there an advantage to 99% to the LLC and mean 1% for less tax, or the LLC has to vest it from the get-go? I'm still confused. Yeah, Anita, what we typically do, if someone creates an LLC, we put the whole property into the LLC, and that person who puts the property in the LLC owns 100% of the shares. If I put a property I have into an LLC and I own 99% of those shares, and my son owns 1% of those shares, the property's reassessed. Okay. So again, this kind of goes back to the question, well, is this easy to do this? Is this a do-it-yourself project? I would say that, some things in law are do-it-yourself projects. I would not put an LLC that deals with real estate as a do-it-yourself project, not at all. The other thing too with an LLC is you have to make a decision early on whether you want to be taxed as a disregarded entity, a partnership, or a corporation. And those all have really significant consequences. And you need your A team, which is your CPA, financial advisor, and lawyer involved in those. Can an intentionally defective grantor trust created in California use Nevada situs? Absolutely. So we still have a free country. This is America. People create Delaware corporations all the time to do business in California. You absolutely can do a Nevada trust for California property for sure, or California situs, right? You can be California resident and use Nevada to create an LLC. You just can't have to register in 2 jurisdictions. Is it the assessor scenario same for states other than California also? Pat, California has the weirdest property tax laws in the whole United States. So I would say that whole thing is about California only. In a lot of other states, it doesn't matter. So, I mean, I know in Texas right now, they're really increasing the property taxes on people because that's a way to get more revenue. They got to build out infrastructure with all those people who moved to Texas, right? They had a big increase in their population. How much is your fee for restatement of existing living trust? That's something we can discuss one-on-one. We do have a webinar. It's our most watched YouTube video, almost 50,000 views. It's how much should a living trust cost? I think you should watch that, and that'll answer your question. Well, that brings us to a close today. Thank you for watching, and have a great day.